Are they on? Ready? All right, we'll get started now. The next panel is, in brief, a rapid-fire comparative analysis and update on national insolvency reform. So this program is going to be a little bit different than your traditional panel where you have members talking. What we're doing is, it's kind of called an Ignite presentation format. So each panelist will have 5 minutes to present on a topic, and they have 20 slides, and each slide automatically advances every 15 seconds. So hopefully the panel will move and it'll keep up with the transitions for each of their slides. So basically, once they start, the title slide will move and then the slides will automatically follow in process. For our first presenter will be Omar Salah from Norton in the Netherlands. Omar?
Hi, good afternoon, ladies and gentlemen, and good evening to the ones in Asia. When we look at the Netherlands, it has been a dynamic space. We've seen a lot of activities which can be divided into 3 areas: the introduction of the Dutch scheme, development with respect to pre-PACs, and recent COVID-19 measures. So looking at COVID-19 measures, we've seen a lot of activity there as well for the last 18 months, different measures that were put in place, basically to make sure that companies could get through this period. In essence, the government put measures in place to make sure that the companies could weather the financial storm, and these measures can be divided into legal measures and financial measures, in essence, forms of government support, including deferral of tax liabilities. Now, looking at legal measures, the most important measure that was put in place was the Temporary Payment Deferral Act 220, which provided companies with a temporary moratorium. Now, that was not extended beyond the 1st of August 2021. At the same time, most of the financial support that was put in place was not extended beyond the 1st of October 2021. So that begs the question whether we will see the wall of debt sometime soon. I know that a lot of restructuring experts are waiting for that at the moment, but let's wait and see. It's a rapid fire, ladies and gentlemen, so I'm moving quickly to pre-PACs in the Netherlands, which here is a form of a pre-PAC sale. We had a practice of pre-PACs, despite that there was no legal basis for it in the Netherlands. And that has actually resulted in a lot of litigation. And what is keeping us divided is the question whether the TUPE directive applies on pre-PACs in the Netherlands. The jury is still out on that one, and that creates some legal uncertainty as well. At the same time, there's been a legislative process for a codification of pre-PACs in the Netherlands, and that is still pending, waiting the outcome of the cases that I just referred to. This year, a consultation was launched to accelerate the introduced pre-PACs. So let's hope that that will get in place soon. And then I can see that my slide is already with the WOA, the Wet Homologatie Onderhands Akkoord, also referred to as the Dutch scheme, especially in an international setting. Now, the WOA is basically a new restructuring tool inspired by the US Chapter 11 and the UK scheme of arrangement. It is also the implementation of the EU directive on insolvency, on restructuring and insolvency in the Netherlands. And in essence, it facilitates an out-of-court restructuring. So it's a debtor in possession proceeding, which affects creditors and shareholders whose rights are affected under the plan. They can vote in class, and the WOA also provides for a cross-class cram-down. It has a lot of special features. Most of them has been inspired by the US Chapter 11 proceeding, including a moratorium, ipso facto deactivation, but also the restructuring of group guarantees and onerous contracts like lease liabilities. The law has been in place since the 1st of January this year, and it has been often used by SMEs in practice. We've seen 65 live cases so far. More than 100 companies have applied for it. There have been by now even 50 court orders that have been published. And when we look at those court orders, there are 3 general trends. One is that a pool of expert judges is looking at these cases, and that has been proving to be successful. The different features work in practice. And as I mentioned earlier, it has been mainly used by SMEs. The first key lessons from this case law is that we've seen a lot of moratoria being applied. Restructuring experts have been quite active in these cases. Some cases relate to rescue financing, and we've also seen the first confirmation of composition plans. Which brings me to my final slide, which is what are the opportunities for the BOA in a post-corona world? I think one is, the question whether more large companies will use it. We are looking forward to see that more often, and it's used by foreign companies. And that brings me to the end of it. Thank you very much.
Thank you, Omar. We'll save questions to the end after all of the panelists, I was very impressed that you were able to keep up with the timing and the transitions. So moving on to our next panelist will be Francesca Burigo from the University Foscari, Venezia. Francesca, when you're ready, as soon as you start, we'll advance the slides.
Thank you, Evan. Hi to everybody. Well, the current situation in Italy comes briefly from these starting points: the Italian bankruptcy law of 1942, the over-indebtedness law of 2012 for consumers and small enterprises, and some special laws for specific sectors or for big-sized corporations. The incentives for a reform in the insolvency law can be found in a dynamic economic scenario, in the impulse of European regulations and directives, and in the COVID-19 pandemic. For these reasons, with a legislative decree of January 2012, the Code of Business Crisis and Insolvency is born, gathering in a unique code more laws, introducing early warnings and the new pre-insolvency tools. The enactment of this new code is still in progress. Amendments to the civil code are already in force in a few weeks, and a tool for viable businesses will be available, and biggest part of all provisions will enter into force in the next 2 years. The first important point of the new law is the negotiated composition of the crisis, addressed only to viable businesses, which starts with a voluntary request of the debtor to cope with distress. No petition must be filed to the court to access to this tool. Indeed, the key role is in the hands of the Chamber of Commerce that manages the web platform for the access, investigates the seriousness of the crisis, and chooses the experts appointed to facilitate negotiations, attesting their utility and the absence of unfair prejudice for creditors. Another innovation of the code is the early warning suggested by the EU Directive on Restructuring and Insolvency. The reform envisages 2 levels of detections of distress: the internal alert of control bodies and the external one of qualified public creditors. The system involves an independent public body called OCRI, which summons the debtor and suggests suitable measures to be adopted for a confidential, quick and effective extrajudicial solution of the crisis. Also, there is a test for enterprises designed by the Italian Council of Certified Accountants, which is working as a thermometer for human temperature. An inadequate score is evidence of distress. Among the pre-insolvency proceedings set by the Italian law, there are the following: the certified recovery plan, the debt restructuring agreement and its variants, and the judicial composition with creditors. Let's see them one by one now. The certified recovery plan is a turnaround program prepared by the debtor aimed at recovering an unbalanced financial situation and involving some creditors or new investors. It is a fully out-of-court proceeding. It shall be certified for its legal and economic feasibility by an independent expert appointed by the debtor, and it is a very confidential tool that grants exemptions from avoidance actions and criminal liability in case of unsuccess. The debt restructuring agreement is a semi-judicial proceeding which foresees an agreement with creditors representing almost 60% of the debts and needs the expert opinion on the feasibility of the plan and the full payment of non-consenting creditors. It can be divided in 2 phases, one out of court for confidential negotiations with creditors and one in court for the confirmation of the plan. During this first phase, it is possible to ask for a stay. Pros of these tools are the priority granted to new financing and exemptions from avoidance actions and criminal liability in case of unsuccess. The variant with extended aspects foresees the division in classes of creditors with the same legal position and bearing comparable economic interest, business continuity, and the opinion of an expert on plan's feasibility, and even the full payment of non-consenting creditors. Law sets for this variant an inter-class cram-down in case of vote of 75% of creditors by value in the class, Moreover, it is possible to have the interclass come down in case of classes of financial creditors with the vote of 50% by value. The facilitated debt structuring agreement is the one with majority consent required by 30% if debtor ensures payment of non-consenting creditors at the contractual date without asking for other facilitations. The last one, the judicial composition with creditors, is a voluntary in-court proceeding subject to creditors' vote and court confirmation. The debtor can create classes of creditors with same legal position and similar economic interest. It can proceed differential treatments for creditors belonging to different classes, but needs the expert opinion on the truthfulness of financial data and use data assumptions and the plan's feasibility. The approval of the proposal should be with the majority of the creditors by value. It is a debtor in possession solution of distress under court oversight, binding for dissenting creditors and enjoying the exemption from avoidance actions and criminal liability in case of unsuccess.
Thank you, Francesca. Next up, moving around the world, where we have Lynette Janssen from Milbank in the UK. Lynette is also a member of the III NextGen Executive Committee. Lynette, whenever you're ready.
Thank you, Evan. Moving then to the UK. In the UK, a new act, the Corporate Insolvency and Governance Act, enters into force in the summer of 2020. And this new act made significant changes to UK restructuring and insolvency law. It introduced several measures, including a new restructuring procedure, we call it the restructuring plan, and certain temporary insolvency and corporate governance measures, mainly to support businesses during the COVID-19 pandemic. Looking first at the restructuring plan. So the restructuring plan is just a new restructuring procedure in the UK Companies Act, and it's largely based on a well-known English scheme of arrangement procedure. Like the scheme of arrangement, it's therefore a court-sanctioned compromise or arrangement among a company and its creditors or shareholders. Looking then at the process it's a largely court-led process involving two main court hearings. We call it the convening hearing and a sanction hearing at the end. And courts are really using already existing case law that has been developed for a scheme of arrangements. It also has, however, important differences when you look at the compared to the scheme of arrangement. Firstly, the company must show a certain level of financial distress. And secondly, it can use a cost-cash cram-down. So when you look here, one of the requirements for the use of a restructuring plan is that the company has encountered certain financial difficulties, which is not required for the use of a scheme. Well, looking then at the cost-cash cram-down, in principle, the voting majority in a class is 75% in value of the creditors or shareholders, so in each class. However, if one or more classes disagrees, doesn't approve the plan, then a court can still use its cost-cash cram-down tool, provided that this dissenting class would not be worse off than the relevant alternative scenario, and at least one in the money class has approved the plan. And similar to scheme of arrangements, the restructuring plan is available to non-English companies, provided that they have a sufficient connection to England and Wales, for instance, because all the main finance documents are governed by English law. Moving then to certain temporary measures introduced by the Corporate Insolvency and Governance Act. Again, they were introduced to support the businesses during the pandemic. Certain measures have expired already, but they're still quite interesting. This act introduced, for instance, a suspension of certain wrongful trading rules for directors. So it removed the threat for directors to be held liable if they continue trading. Secondly, this act provided that no winding up petition could be presented to court on the basis of a statutory demand. But again, this measure expired at the end of September. Then thirdly, where the unpaid debt of a company was due to the pandemic, also no winding up order could be made. So this was the third expired temporary insolvency measure. However, a new measure has been introduced recently. Since the 1st of October, new restrictions on winding up petitions apply, and these restrictions will apply until the end of March next year. And the goal of these measures is, at least what the legislator said, is to protect companies from aggressive creditor enforcement as the company now finally opens up again. So this new act introduces 3 requirements that have to be met before a court can make a winding up order. Firstly, the debt owed to the petitioner or petitioners has to be at least £10,000. The second requirement is that the creditors first has to send a proposal for the repayment of debt to the debtor, and the debtor has to then be given 21 days to respond to that proposal. And thirdly, in relation to commercial rents, the non-payment of the debt can't be related to the COVID-19 pandemic. So these are the 3 new requirements for a winding up order by the court. Thank you very much.
Thank you, Lynette. So staying with the UK for a moment, because there is a lot of updates in the UK, we will have Natalie Scoones from Travers Smith also present on updates in the UK.
Thank you, Evan. Hi, everyone. Hi from London. Following on from Lynette, I'm going to talk about the new freestanding moratorium under UK law, some of the new changes regarding ipso facto clauses, and recent proposals for dealing with commercial rent arrears. So moving first to the freestanding moratorium, this is a new process introduced by the Corporate Insolvency and Governance Act. Its purpose is to provide a company in financial distress with breathing space to explore its restructuring options free from the majority of creditor action. It's a relatively simple process instigated by a company's directors, which provides protection from creditor action whilst the directors retain control. The initial term of the moratorium is 20 business days, which may be extended by the directors and then with the approval of creditors in the court. A monitor, an insolvency practitioner, must be appointed to oversee the moratorium. The monitor must confirm that the moratorium and any related restructuring will result in a rescue of the company as a going concern. So what issues arise in considering the moratorium? Well, first, the company must be able to pay its debts falling due during the moratorium. So it will not be useful for many companies that are in significant financial distress. And the moratorium is open to challenge by affected creditors. Further, you need to find a monitor that will continually assess whether the moratorium is likely to result in the rescue of the company as a going concern, and they must terminate the moratorium if necessary. So the associated liability for monitors may make this difficult for insolvency practitioners to take on. Moving quickly to ipso facto clauses, previously we basically had very little prohibition on contractual provisions that permit a party to terminate upon the other party's insolvency, other than in relation to certain utilities. The new position is that suppliers are prevented from relying on any contractual provision which would allow the supplier to terminate or do any other thing as a result of its customer becoming subject to a relevant insolvency procedure. The new position is that suppliers are prevented from also relying on contractual provisions that would allow, I would just note that, yes, they can't rely on breaches pre-insolvency if they weren't exercised once insolvency begins. Now, that only applies to suppliers of goods and services, with some exclusions, and insolvent companies are not protected from fresh breaches post-insolvency. The supplier could terminate on that basis, depending on the terms of the contract. Now, looking at the situation with rent arrears in the UK, since March 2020, companies have largely been protected from landlord action for unpaid rent, but this protection will end in March 2020, when companies will owe up to 24 months of unpaid rent. There are some estimates that there's approximately £6 billion of unpaid rent across the UK, and many landlords obviously claim that this is not just due to COVID, that some rent is just not being paid. Now, from March 2022, landlords will be able to exercise their forfeiture rights. They'll be able to file winding up petitions in respect of arrears, and we have a concern, obviously, that there's a cliff edge approaching. So a short time ago, the UK government announced that new legislation would be tabled, which will encourage landlords and tenants to reach consensual agreement over rent arrears. A failure to reach an agreement would lead to a mandatory arbitration procedure. The legislation is still awaited. However, we understand that landlords will be expected to share the pain, but only in relation to rent arrears that accrue during periods of forced closure due to COVID. So this obviously raises a number of questions. What does share the pain mean? What will the arbitration process involve? Who will be the arbitrators? And will the system be overwhelmed due to the volume of disputes in the market? Despite the promise of a new process, it's fair to say that companies may still expect to pay large rent arrears bills come end of March 2022. And together with phasing out the other temporary measures, this will put significant pressure on companies attempting to recover from the pandemic. So watch this space. To wrap up, unwinding of temporary protective procedures that both I and Lynette have discussed, continued high levels of debt from the pandemic, and the new restructuring procedures available to companies will lead to some very interesting times ahead.
Thank you. So next, we are going to move to Carolina Iwamoto from Pinheiro, Neto, Advogados. Whenever you're ready.
Thank you. Well, speaking about Brazil, in 2020, the congressional debate around possible provisional measures in response to the COVID-19 pandemic crisis reignited a 5-year-old debate about a comprehensive amendment to a 2005 insolvency law, leading to a substantial reform effective January this year. Today, we'll be focusing on the general insolvency framework applying to business companies and individual business owners. The reform introduced changes to all types of proceedings available to such business enterprises, which are the judicial reorganization, the extrajudicial reorganization, and the bankruptcy liquidation. We'll focus today on main aspects of the reorganization proceedings. The judicial reorganization is a tool designed to reorganize viable business in distress. The purpose is to create a negotiation environment between debtor and creditors of different profiles, labor, secured, unsecured, and small suppliers. The reform modified various aspects of the judicial reorganization and included new features, most of which to address challenges faced by practitioners in view of the growing complexity of restructuring cases in recent years. The reform also modified several aspects of the extrajudicial reorganization to make it more appealing, whereas essentially it's a judicial proceeding whereby debtor may seek to bind dissenting creditors under a prepackaged reorganization plan supported by the requisite majority of creditors. In the pre-existing regime, asset sales were incentivized in judicial reorganization and liquidation, where assets could be sold free and clear of debtors' liabilities subject to certain conditions. The reform expanded those safeguards and extended them to the extrajudicial proceedings as well. The revised framework now expressly recognizes that any and all types of assets may be sold succession-free, including equity and the business itself, which solves a debate that existed under the pre-existing regime. Similarly, in order to incentivize efficient workouts, the reform also included safeguards to creditors in case of debt to equity conversion or replacement of management. Investors are also protected in case of capitalization. Other changes were included also in respect to debtor in possession financing, given that the pre-existing regime was perceived as insufficient to foster a safe environment for new money lenders. As a general comment, the reform did fail to add efficient tools to foster financing, such as priming lien, for instance. But a noteworthy modification is definitely that the new money moved up in line and now enjoys super priority in case of liquidation. Other important new provisions protect asset sales and financing transactions from being declared null and void if the relevant court authorization is later overturned after closing or disbursement. This is one of the most praised innovations, as it's expected to solve practical challenges. In practice, investors often need to condition closing to or funding to a certain level of protection and stability, especially in high litigated cases, and access to liquidity and new money can be challenging. Another new feature that has been long awaited is creditors' ability to submit an alternative plan of judicial reorganization. In the original regime, debtor held exclusivity to submit a plan and therefore held considerable leverage over creditors. In the new regime, creditors may now submit an alternative plan if debtor's plan is either rejected or not voted by the end of the reorganization's stay period. Creditor's plan does depend on such a few requirements, such as a minimum support by other creditors and safeguards to shareholders. Alternative dispute resolution mechanisms are now expressly provided in the law, including the pre-filing stage, which is also an innovation that is aligned with the scope of promoting extrajudicial workouts. In the extrajudicial reorganization, for instance, there are a few innovations that bring more efficiency to the proceeding, such as a stay period, lower quorum to bind dissenting creditors under the plan, which is a drop from 60% to 50+1, a consent solicitation process that may be carried out post-filing, and the broader scope of claims subject to the proceeding. Lastly, the insolvency framework now encompasses provisions on cross-border insolvency that mirror the UNCITRAL model law on cross-border insolvency. Our former regime was completely silent on that matter. As a general view, it's clear that the reform introduced numerous advances to the legal framework, but there is also a general perception that it has left extensive room for discussions in various aspects. So definitely courts and practitioners will certainly continue to play a material role in shaping how these new provisions will be applied. Thank you.
Thank you. And finally, we are going to get an update from India from Ishana Tripathi of OP Jindal University. Ishana, whenever you're ready.
Thank you, Evan. Good evening, good afternoon, and good morning, wherever you're logging in from. India in general has had and is known for scattered legislation, and there has been many amendments in the space of insolvency as recent as 2016, and the law was implemented in 2017. So not much time between the insolvency legislative change, executive change, policy change, regulatory change, and the COVID-19 impact in 2020 for India. So the IBC amendment was a creditor-driven amendment. So it is a creditor in control process. It is not a creditor in possession process. And in the COVID-19 space, you saw prepackaged insolvency geared at MSMEs, which are impact sectors, wherein MSMEs would themselves drive the insolvency process. Housing, MSMEs, SMEs have seen even regulatory changes through RBI schemes, and banking changes in the form of asset reconstruction companies and public sector bank mergers, which have happened at a large scale in India over the past 5 years in specific. Now, the IBC legal change is very important to understand because you looked at regulatory corporate strategic debt restructuring schemes that were not working. You had high courts and tribunals where there were insolvency cases, winding up cases that were pending that took 10 to 12 years of resolution. In IBC, with the aspect of NPA cleanup, you saw regulatory reference to insolvency and creditor initiations with a 330-day window for resolution in total. However, with COVID-19 in 2020, because the IBC was still being implemented when you had a global shutdown, you saw a change in the way the law was being implemented. So the IBC basically looked at a default threshold trigger, which is no longer the case, and the default threshold moved from 100,000 to 1 million, whereas the prepackaged insolvency situation did not needed about 100,000 change, and the MSME sector therefore looks at a focused resolution under the IBC, along with restructuring schemes which were consolidated and introduced with COVID relief packages. Now, as an update, as we speak today, these COVID relief packages for MSMEs and SMEs are no longer active. However, reorganizations under these schemes are still ongoing. And in parallel, you're looking at the IBC implementing a different kind of restructuring and a resolution model. Now, the public sector bank stress, bank mergers are a very important part of how the insolvency law is being implemented as of date. We were suspended from insolvency usage for a year. Now that we're active, you're looking at ARCs being the mechanism for NPA and public sector bank cleanups alongside the insolvency and bankruptcy code. Two big ARCs that have been implemented are slotted to solve a 27 billion USD NPA problem. And I like to call the pipeline split into local, international, and local. And locally, you're looking at the implementation of individual insolvencies and bank insolvencies as an up next. Internationally, you're looking at the same thing transposing into cross-border. Recently, you're looking at a Dutch-India case scenario and cooperation scenario under no treaty, because India does not subscribe to the UNCITRAL model law as a case resolution. And here there is still an open-endedness in terms of enforcement of insolvency proceeding, and you're looking at BIT insolvency process issues as well in the telecom sector specifically. India has lost its BIT against a retrospective tax case, and that particular company is right now in a potential insolvency. New update, there is a telecom relief package that has been introduced in India in the past week, and you're looking at creditor governance and enforcements becoming an issue. On an open side note, inter se rights-based resolution is perhaps the next step. And across the jurisdictions, we've seen a lot of change, a lot of impetus on reorganization, restructuring, and insolvency changes for essentially economic development and also sort of controlling the impact of COVID-19. And much is to be seen. And I'm going to leave it at that. Thank you very much for staying with us.
Thank you, Ishana. If we could bring back all the panelists, I'll open the floor to see if anybody virtually or in person has questions for the panelists. All right, seeing as there's no questions virtually or in person, I appreciate all your time. I know it's certainly not easy to speak on a 5-minute time constraint with the slides moving. So thank you all very much. I appreciate it. And we will have a short break to 2:30 for the next panel. Thank you.
Thank you.
Thank you. Bye-bye.